Who protects you when it's the protector you fear, when the badge becomes a weapon, not a shield? From Daniel Holtzclaw, who stopped women he knew no one would believe, then used fear to violate them, to David Carrick, who bragged, "I am the law," as he lured them behind closed doors.
When he searched me, he searched under my clothes. He patted me down up under my clothes. And he opened the door, he told me to get out and pull my pants down.
What you're about to witness are 6 unsettling cases where those sworn to protect became the monsters themselves. Daniel Holtzclaw case. The streets of northeast Oklahoma City were supposed to be safer with officers like Daniel Holtzclaw patrolling them. Instead, they became hunting grounds for a predator with a badge. Holtzclaw, a former college football linebacker standing 6 to 1 inch who joined the Oklahoma City Police Department after failing to make it to the NFL, transformed from a symbol of protection into one of terror for at least 13 African-American women between December 2013 and June 2014. Holtzclaw specifically targeted vulnerable women, those with histories of drug abuse, prostitution, or outstanding warrants, calculating correctly that their credibility would be questioned if they ever reported him. His pattern was methodical and deliberate. He would conduct traffic stops or street encounters, isolate his victims, and then use his authority to coerce them into sexual acts by threatening arrest or leveraging their fear of police. The case might never have come to light if not for the bravery of 57-year-old grandmother Janie Ligens, who, unlike Holtzclaw's previous victims, had no criminal record.
I'm like, "What? You want me to take my pants down?" Then he was like, "Yes." I said, "Oh, no, sir." I said, "You're not supposed to do that, sir."
When Holtzclaw stopped her while she was driving through the area on June 18, 2014, forced her to expose herself, and coerced her into performing oral sex, she reported the assault immediately. Her complaint triggered an investigation that would uncover a disturbing pattern of sexual violence.
Backed up and he zipped his pants up, and he moved back, and I just got out his police car and walked towards my car thinking he was going to shoot me in the back. And he let me live to tell the story. Big mistake.
As detectives began reviewing Holtzclaw's patrol records, warrant check logs, and automatic vehicle locator data, they identified additional potential victims. The women's stories were strikingly similar. Holtzclaw would isolate them, abuse his authority, and sexually assault them, confident that no one would believe their accusations against a police officer. Among his victims was a 17-year-old girl whom he on her mother's porch after threatening her with arrest. The investigation culminated in a trial that began on November 2, 2015. Despite being tried by an all-white jury, Holtzclaw was convicted on December 10, 2015 of 18 counts involving 8 victims, including 4 counts of first-degree rape. On January 21, 2016, he was sentenced to 263 years in prison to be served consecutively, effectively a life sentence. What makes this case particularly disturbing is not just the crimes themselves, but how close Holtzclaw came to getting away with them. If not for Ligens, a victim whose social standing made her complaint impossible to dismiss, Holtzclaw might have continued his predatory behavior indefinitely. The case exposed how power, authority, and systemic biases can create perfect conditions for predators to operate with impunity, particularly when targeting marginalized communities. Even after his conviction, Holtzclaw has maintained his innocence, filing multiple appeals, all of which have been denied. His case stands as a stark reminder of the devastating consequences when those entrusted with public safety betray that trust in the most fundamental way possible. Just as Holtzclaw weaponized his authority against the most vulnerable, another officer across the country was doing the same, this time under the neon lights of San Diego. Anthony Aravalo's case. In the vibrant nightlife district of San Diego's Gaslamp Quarter, Officer Anthony Aravalos wasn't just enforcing the law, he was systematically breaking it. Over an 18-year career with the San Diego Police Department, Aravalos developed a disturbing pattern of misconduct, focusing particularly on young women suspected of driving under the influence. His colleagues had even mockingly nicknamed him the Las Colinas Transport Unit, referring to the women's jail, a red flag that went unaddressed for years. Aravalos's method was calculated and predatory. During traffic stops, he would pull over women who were often intoxicated or vulnerable, then offer them a choice: perform sexual acts or face serious legal consequences like DUI charges. Using his authority as a shield, he created situations where victims felt they had no choice but to comply with his demands, exploiting the power imbalance inherent in police encounters. The case that finally brought his crimes to light occurred on March 8, 2011. Aravalos pulled over a woman referred to as Jane Doe for failing to use a turn signal in the Gaslamp Quarter. Suspecting she was intoxicated, intoxicated, he proposed a deal. She would provide her underwear and allow him to touch her in exchange for avoiding arrest. He directed her to a nearby 7-Eleven bathroom where the assault took place. Unlike previous victims who had remained silent, Jane Doe reported the incident the next day. Officer Kelly Besker promptly escalated the complaint, triggering an investigation that included 2 pretext phone calls in which Aravalos made incriminating statements. After his arrest and public identification, 6 more women came forward with similar allegations spanning from September 2009 to March 2011. Following a trial in late 2011, Aravalos was convicted on November 17th of 8 felonies and 4 misdemeanors involving 5 women. On February 10, 2012, Judge Fraser sentenced him to 8 years and 8 months in prison, calling him a crooked cop who had abused vulnerable women. Though Aravalos appealed, arguing prosecutorial misconduct and insufficient evidence, his conviction was ultimately upheld. What's perhaps most troubling about the Aravalos case is how many warning signs were ignored. A 1999 incident involving a mentally unstable woman performing a sex act with a baton in Aravalos's patrol car was witnessed by another officer but only reported to a supervisor, with no record in Aravalos's personnel file. In February 2010, a woman accused him of sexual assault during a DUI stop, but despite the San Diego Police Department recommending charges, District Attorney Bonnie Dumanis declined to prosecute, citing insufficient evidence. Aravalos returned to patrol without discipline. The financial impact of his crimes was substantial. Jane Doe settled her federal lawsuit for $5.9 million, and by 2014, the city had paid at least $2.3 million across multiple victims. Aravalos served only half his sentence, gaining early release in April 2016 due to good behavior and California's prison overcrowding policies. His case, however, prompted significant reforms within the San Diego Police Department, including mandatory misconduct reporting and the deployment of body-worn cameras, changes that came too late for his victims, but might protect others in the future. While Aravalos prayed during traffic stops, what happened next in the UK was even more terrifying: a fake arrest and a betrayal that ended in tragedy. Wayne Couzens case. On the evening of March 3, 2021, 33-year-old marketing executive Sarah Everard set out to walk home from a friend's house in South London. It was a journey she had every right to make in safety. Instead, it became the final moments of her life at the hands of someone sworn to protect the public. Wayne Couzens, a 48-year-old serving Metropolitan Police officer, abducted Everard by staging a false arrest, claiming she had breached COVID-19 lockdown regulations. Using his police warrant card and handcuffs, he created an illusion of legitimacy that left Everard with no choice but to comply. What followed was a crime of such calculated horror that it would shake public trust in the police to its core. After handcuffing Everard and placing her in a hired Vauxhall Crossland, Couzens drove her to a rural area near Tilmanstone, Kent, where he and strangled her using his police issue belt. He later burned her body in Woodland near Ashford and disposed of her remains in a pond. The investigation revealed the premeditated nature of Couzens' crime. He had booked the rental car, conducted reconnaissance, and purchased items like adhesive film to aid his attack. Perhaps most disturbing was his attempt to resume normal life afterward, even taking his family to the woods where he had burned Everard's body as if on a casual outing. CCTV footage from a London bus and the hire car company's records were crucial in identifying Couzens, leading to his arrest on March 9th. When questioned, he fabricated an elaborate lie about being coerced by an Eastern European gang to kidnap Everard due to alleged debts, a story quickly disproven by forensic evidence.
They're a group, a gang, whatever, and they told me, well, I need to go and pick up girls and give them to them. So I said, it's happening. And it then came through that they're going to harm my family, take them away, and they'll use them instead. At that point I had no option to try and find somebody. So I don't, there's a couple of names. I was told a place to take her. That's it.
On July 9th, 2021, Couzens pleaded guilty to kidnapping and murder. On September 30th, Lord Justice Fulford sentenced him to a whole life order, an extremely rare penalty in the UK justice system, meaning Couzens will never be eligible for parole. The judge equated Couzens' abuse of police authority to terrorism, stating it fundamentally undermined public trust in law enforcement. Perhaps the most infuriating aspect of this case is how many warning signs were ignored. Couzens had a history of sexual offending, including at least 8 reported incidents of indecent exposure between 2015 and 2021. Just days before Everard Everard's murder, he had exposed himself at a McDonald's drive-thru, with staff reporting his car registration and credit card details to police. The Metropolitan Police failed to investigate adequately. Some colleagues had even nicknamed Cousins the Rape and knew of his interest in extreme pornography, yet these concerns were never formally reported. The Angiolini inquiry, published in February 2024, revealed that Cousins had sexually assaulted a child and attempted to kidnap a woman at knife point before joining the police, allegations that were never acted upon. The Cousins case sparked national outrage and a reckoning about women's safety, police accountability, and institutional failures. Vigils were held across the UK, including a controversial gathering at Clapham Common that was dispersed by police, further inflaming public anger. The case led to significant policy proposals, including potential laws to criminalize public sexual harassment and reviews of police vetting procedures. For many women, Everard's murder crystallized a fear they had always lived with, that even when doing something as simple as walking home, their safety could never be guaranteed, not even by those meant to protect them. Shockingly, Cousins wasn't the only predator within the very unit sworn to protect the public. What came to light next would reveal an even wider pattern of abuse inside the force. David Carrick case. Imagine placing your trust in a police officer, only to discover he's one of Britain's most prolific sexual predators. This was the horrifying reality for at least 12 women who encountered David Carrick, a Metropolitan Police officer whose reign of terror spanned nearly 2 decades. Born in 1975 in Salisbury, Wiltshire, Carrick joined the Metropolitan Police in 2001 after a brief stint in the British Army. By 2009, he had transferred to the Parliamentary and Diplomatic Protection Branch, an elite armed unit guarding key sites like the Houses of Parliament and embassies positions that gave him extraordinary authority and access to vulnerable women. Behind the facade of his uniform, Carrick systematically targeted and abused women he met through dating websites or in person. His pattern was one of manipulation, isolation, and control, dictating victims' appearance, diet, and social interactions, using financial dependence to trap them and subjecting them to physical and sexual violence. He often claimed his police status made him untouchable, telling victims, "I am the law," or "I am the boss."
This is the allegation that's been made to us, okay, sir?
There's no necessity.
Yes, there is.
I've only been a police officer for 20 years.
Right.
The scope of Carrick's crimes is staggering. 49 charges, including 24 counts of 9 counts of sexual assault, 5 counts of assault by penetration, 3 counts of coercive control, 3 counts of false imprisonment, 2 counts of attempted and various other sexual offenses, representing at least 85 separate incidents, with 71 being sexual in nature. His first known rape occurred in 2003, but his crimes intensified between 2015 and 2020, with escalating violence and degradation. What makes this case particularly disturbing is how many opportunities were missed to stop him. Carrick came to police attention 9 times between 2000 and 2021 for allegations including rape, domestic violence, harassment, assault, and burglary. Yet no criminal sanctions or misconduct findings were ever pursued, and he passed vetting in 2017 despite these reports. Even before joining the police, he had been linked to a sexual assault on a child and an attempted kidnapping at knife point allegations that were never acted upon. The case only came to light after the publicity surrounding Wayne Cousins, another Metropolitan Police officer convicted of murdering Sarah Everard, prompted a woman to report being by Carrick in September 2020. He was arrested on October 2, 2021, and initially pleaded not guilty, but later admitted to 49 charges in December 2022 and January 2023. On February 7, 2023, Justice Bobby Chima Grubbs sentenced Carrick to life imprisonment with a minimum term of 30 years and 239 days, describing his crimes as a systematic catalog of violent and brutal sexual offenses. The judge highlighted the irretrievable devastation caused to his victims, many of whom described profound trauma. One said she felt she had encountered evil after Carrick held a gun to her head. The Metropolitan Police acknowledged their catastrophic failures in this case, with Assistant Commissioner Barbara Gray stating, "We should have spotted his pattern of abusive behavior." Commissioner Sir Mark Rowley apologized, admitting that the force let down women across London and had not been rigorous enough in vetting or misconduct investigations. In the aftermath, the Independent Office for Police Conduct launched 4 investigations into how complaints against Carrick were handled, and an independent inquiry chaired by Lady Elish Angiolini was established to examine systemic failures. 6 of Carrick's victims announced plans to sue the Metropolitan Police for breaching their human rights, and in October 2024, Carrick faced additional charges, including allegations of indecent assault on a girl under 14 from 1989 to 1990. The Carrick case, coming so soon after the Cousins murder, shattered public confidence in the Metropolitan Police and raised fundamental questions about police vetting, misconduct handling, and institutional culture. It stands as a horrifying example of how abuse abusers can exploit positions of authority to perpetrate crimes for decades, while systems designed to prevent such abuse repeatedly fail. And the problem wasn't isolated to one side of the Atlantic. In California, a highway patrol officer exploited his access to personal information to stalk and harass women with alarming precision. California Highway Patrol case. In the sprawling highway network of Contra Costa County, California, a disturbing case of police sexual misconduct unfolded that would expose vulnerabilities in oversight systems and the unique dangers women face during routine traffic encounters. The case centered around California Highway Patrol, CHP officer Dion McGrew, also identified as James McGrew in some reports, whose predatory behavior affected nearly 24 women during vehicle inspections and other interactions in 2015 to 2016. McGrew's pattern of misconduct came to light when a woman reported that he had harassed her after obtaining her contact information from a towed vehicle form in 2015. After accessing her personal information through police databases, he began a campaign of harassment that included sending unsolicited explicit images and repeatedly contacting her, behavior that intensified even after she blocked his number. McGrew demonstrated a disturbing ability to circumvent normal boundaries, using his access to police systems to find her new phone number after she blocked him, illustrating how police authority can be weaponized for stalking and harassment.
He positions his patrol car on the side of the parking lot and opens the two doors of his SUV patrol car and positions her between the two doors and again proceeds to grope her genitalia or breast in a sexually inappropriate manner.
This wasn't an isolated incident. As the investigation expanded, nearly 24 women were identified as victims of McGrew's sexual harassment. Many were approached during vulnerable moments, during traffic stops, after accidents, or during vehicle inspections, situations where McGrew's position as a CHP officer gave him both authority and access to personal information.
It's very difficult to talk about this thing, that he was a police officer. She didn't know what else he could do to her. She was just very traumatized.
The women targeted by McGrew faced a common dilemma for victims of police misconduct. Who do you call when the police are the problem? One victim spoke anonymously to KQED, citing fear of retaliation. Her experience highlights how power imbalances can silence victims, especially when the perpetrator wears a badge and has the weight of law enforcement behind them. What makes this case particularly troubling is how it was handled once reported. After an internal investigation confirmed McGrew's misconduct, the CHP fired him in 2017 but never referred the case to prosecutors for criminal charges. This decision effectively allowed him to avoid criminal consequences for behavior that, in other contexts, might have resulted in stalking or harassment charges. The case exemplifies what critics describe as a gap in police accountability, where internal discipline may occur, but criminal prosecution remains rare. The McGrew case isn't unique. It reflects a pattern researchers have identified as driving while female, where traffic stops become opportunities for officers with predatory intentions. This phenomenon accounts for about 25.5% of police sexual misconduct cases, according to some studies. These encounters are particularly dangerous because they often occur in isolated locations, at night, and in situations where the officer has significant discretionary power. The CHP's handling of complaints against McGrew also revealed systemic issues. Some women reported facing suspicion or intimidation when reporting his behavior, reflecting wider problems in how allegations against officers are received and investigated. The case emerged alongside other high-profile incidents of police sexual misconduct in California, including Anthony Aravalos in San Diego, suggesting a more pervasive problem within law enforcement culture. Unlike some cases where video evidence or multiple witness accounts exist, much of McGrew's misconduct occurred via text messages, phone calls, or in one-on-one situations during traffic stops. This made the investigation heavily dependent on victim testimony and electronic evidence, highlighting the challenges in prosecuting these types of cases. While McGrew was ultimately removed from his position, the case raises troubling questions about whether the response was sufficient. His termination prevented him from continuing to abuse his position with the CHP, but the lack of criminal charges meant no permanent record that might have prevented him from seeking employment in other law enforcement agencies or security positions. The Contra Costa CHP case stands as a stark reminder of the vulnerabilities citizens, particularly women, face during routine encounters with law enforcement and the need for stronger oversight, accountability measures, and criminal prosecution when officers abuse their authority for sexual purposes. While some officers manipulate their power from behind the scenes, others use their authority right in front of their victims, as we see in this next disturbing case of Gianna Anderson. Gianna Anderson case. On the night of October 16, 2015, Gianna Anderson's life changed forever during what should have been a routine traffic stop in Phoenix, Arizona. Anderson, a healthcare worker with no prior arrests, was pulled over by Phoenix police officer Anthony Armour in a dark parking lot for a minor vehicle registration issue. What followed would expose not only one officer's predatory behavior, but a pattern of institutional failures within the Phoenix Police Department. As the encounter began, Anderson immediately sensed something was wrong. When she politely asked why she had been stopped, Armour reportedly responded, "Don't play dumb with me," setting an aggressive tone from the start. Anderson later recalled, "It was at that point I knew that I've lost control and something is not right here." Her instincts would prove tragically accurate. After running Anderson's information, Armour ordered her out of the vehicle. Concerned by his demeanor, she requested a supervisor, but Armour allegedly interrupted, saying, "I don't need my supervisor, just get out of the damn car." When Anderson attempted to record the interaction on her phone for safety, Armour reportedly grabbed her wrist, stopped her, forcibly pulled her out of the car, and handcuffed her. What happened next forms the core of Anderson's allegations. While handcuffed, she claimed Armour conducted an invasive search, running his hands under her shirt, cupping her breast, and moving his hands into her pockets, down her pants, and along her thigh. The search allegedly involved groping of her pubic region and breast, far beyond any legitimate law enforcement purpose. Following this assault, Anderson was booked for resisting arrest, threatened with a 6-month sentence and a $2,500 fine, and taken to jail. 5 months later, in March 2016, Anderson filed an official internal complaint against Armour through her attorney, citing fear of retaliation and distrust in the police as reasons for the delay. The Phoenix Police Department's investigation was deeply flawed. They failed to obtain surveillance video from nearby businesses or interview witnesses. Ultimately, they cleared Armour of misconduct, despite the serious nature of the allegations. Refusing to be silenced, Anderson filed a federal lawsuit against Armour and the city of Phoenix under 42 U.S.C. Section 1983 and Arizona state law, claiming sexual assault and excessive force. The case went to trial, but in late October 2020, the jury ruled in favor of Armour and the city, finding no sexual assault occurred. Anderson appealed the verdict, arguing the trial was grossly inequitable due to several judicial errors. The judge had not allowed the jury to hear that Armour was on the Maricopa County Brady List, a record of officers with documented dishonesty, which could have undermined his credibility. Evidence of Armour's prior alleged sexual misconduct, including a 2010 accusation by a fellow female officer, was excluded. Additionally, Armour testified that he had recorded portions of Anderson's traffic stop on his personal cell phone, but disposed of the phone in late 2015 or early 2016, claiming it was broken. Anderson's attorneys argued they were not allowed to fully question Armour about this potential spoliation of evidence. Despite these concerns, the appellate court affirmed the district court's decisions, finding that Anderson failed to prove Armour had a duty to preserve the recording or destroyed it with intent to deprive her of its use. What makes Anderson's case particularly disturbing is how it fits into a larger pattern of misconduct by Armour and systemic issues within the Phoenix Police Department. Armour had a documented history of misconduct allegations, particularly involving women. In 2010, a female Phoenix officer accused him of sexually assaulting her after a party where she had been drinking. In 2011, a woman accused Armour and a colleague of pulling her over without cause into an alley at 2:30 a.m. and interrogating her alone. In 2012, Armour was investigated for allegedly engaging in sexual activity with a woman he was investigating for drug offenses. Just 3 weeks after Anderson's traffic stop, Armour unlawfully entered a woman's apartment, falsely arrested her, lied to his supervisor, and had her booked into jail despite orders to release her. For this incident, he was suspended for 80 hours but not fired, and the case was not reported to the Arizona Peace Officers Standard and Training Board, which could have revoked his certification. Armour retired in 2020 under an accidental disability claim, avoiding further disciplinary action. Anderson's case exemplifies how difficult it is for victims of police sexual misconduct to obtain justice, even when the officer in question has a documented history of similar behavior. Her story highlights the need for greater accountability, transparency, and reform in how allegations of police sexual misconduct are handled, both by departments internally and by the criminal justice system as a whole. If you liked this video and looking for more similar content, check out the suggested cards popping on your screen.